Welcome, everybody. I'm glad to be presenting this webinar. I wanted to say to get started that this is a webinar not necessarily for mediators, but it's going to feel a lot that way. I believe that a lot of people that do divorce work, mostly CDFAs, and mediators, I suppose some therapists to a certain extent, can work with couples before the actual divorce process gets started, meaning before the paperwork battles start, and can help them in a neutral fashion. And I know that the laws are different in every state when it concerns these things. I'm in Virginia. We have a fairly robust program, but it's certainly not like it is in California where they have it completely teched out. So I do need to say that I'm speaking from the background of somebody that mediates in Virginia. And I would say that I probably use my CDFA training as much or more than my legal background, not to mention my own personal experience and, of course, the layered experience of working with so many couples. So I wanted to start with what is a divorce neutral or mediator. And by the way, I'm going to do questions halfway in. So if you have any questions around the midpoint, I'm going to stop and ask for that. So I have defined mediation or a mediator or a divorce neutral as a brave person who sits between divorcing parties and helps them divide their assets and debts and determine support without giving them advice. This may be done with or without attorney representation. And I say it's a brave person because that's what people call me a lot. A lot of people ask, how on earth do you sit between the parties when they're going through a divorce? But what I found in my years of doing this, and I've been mediating exclusively for a little over 7 years, is that the people tend to self-select. If a husband and a wife are coming to a neutral to help them divide and distribute their assets and set support, chances are they are not going to be acting in a manner unbecoming of people that are trying to settle their divorce amicably. I rarely have to toss people out of my mediation room for bad behavior. The point about not giving advice, that is really hard for people to wrap their head around. That is very important, at least if you're a certified mediator in my state, that you not give advice, you give information. And I'm going to be going into that in great detail a little bit later. I know that people have a lot of questions about that. This work being done with or without attorney representation, I know that there are mediation firms in my town that disallow clients that don't have attorney representation, but the vast majority of my clients do not. I always recommend that they have attorney representation, but it's completely up to them. The important thing to remember is that couples that are coming to a neutral are more often than not there to save money and avoid the emotional turmoil of litigation. And a lot of them, I'm an attorney so I can say this, a lot of them just straight up do not like lawyers. And they will not go to a lawyer, whether they're recommended to do that or not. So it is up to them. 3 primary roles of a divorce neutral or mediator. Once again, I will go into much more detail on this later. First of all, you're an educator. Second, you are an information manager. And third, you're what I call a referee. The referee part is what I refer to as the art of mediation. Next slide, you see all those hats up there. I put those up there to remind everybody that if you're functioning as a neutral in a divorce situation, helping people to settle their divorce, whether you're calling yourself a mediator or not, you need to be crystal clear both in your own mind, and you need to make it clear to the people that you're working with what your role is. And once you determine that, you need to follow whatever code of ethics there is for that discipline, follow the law, follow the rules of your jurisdiction and your certifying organization, and just make sure that everybody understands what the purpose of the meeting is and what your roles are. I wanted to note that some jurisdictions, such as mine, do not require that mediators be certified. However, if you are certified by the state, such as myself, you better follow the rules. I think we all know that unauthorized practice of law is very serious. Most states it is a crime, so you have to be very careful about that, about not giving advice, legal advice. And I also wanted to point out that if you're in a state like mine, where the Code of Ethics has essentially never been tested, maybe in a tiny way, but almost not at all, according to my certifying organization, you're essentially a guinea pig. Another reason why I used the word brave on the first slide. Another thing I wanted to mention that's not on the slide, but I know a lot of financial planners shy away from being a neutral because they want to be able to hold on to those clients later in their role as a financial planner. Know what's permitted in your jurisdiction. Maybe you can do that. Maybe with the permission of clients you can. In my personal experience, when I went through my divorce, my ex and I double utilized during the divorce one of our CPAs, our financial planner, who was also our broker, and our estate planning attorney, and then we continued to use those same people for years. So it is possible. This next slide is a reminder slide that, in a nutshell, clients will come to you as a neutral to help them settle their divorce because they're looking for a fair process. This is very important to a lot of people. They'll need to feel that it's a fair process, and this starts from your first phone call with them. They want an efficient process. If they want a long, drawn-out process, they'll litigate. You need to be in control of the sessions, but balance that with compassion. So they're going to be upset with you if they end up with a huge bill and 9 million hours of session time. So you want to be efficient, but at the same time, you don't want them to feel pushed. Once again, that's the art of doing this. And settlement, that's what they're there for. You need to know that sometimes clients will make decisions that are, they're okay. They're certainly not what you would have advised them. But these are people that need to move on with their lives. Your job is to make sure that they understand the possible and potential implications of their decisions and how those decisions compare with the norm. How they compare with, what you'd recommend if they were your regular non-divorce client. What might happen in court if you know. You're going to take these people as you find them. What I've noticed is if people come to me with tons of debt, they're oftentimes the same people that I cannot figure out for the life of me how on earth they're going to afford to be divorced. But they're going to do it. They're going to do it. Sometimes people come to me and they have more money than I can ever imagine having. And they're sure that they're going to come out of the divorce poverty-stricken and living under a bridge. So you're just going to have to work help them settle their case. Once again, it might not be the way that you would settle the case. This next slide, I know it's a little overwhelming. I got in trouble with my graphics person for this. But I wanted to get this all on one screen because this is going to be a lot of personal choice. These are my examples, and you might not even choose to do things this way. But I find, and I do settle most of my cases, and I believe the primary reason that I do this, one of the primary reasons, is that I know a lot about my clients before they come in and see me. I talk with each of them individually on the phone for 20 to 40 minutes. I think it says on my website 20 minutes free. But I talk with them in private. It's completely confidential. I don't repeat it to the other person. I don't charge for this, which makes my business consultant crazy. I might change that one day, but I notice when I'm not charging, the people are very relaxed, and they tell me a lot of information that helps me settle their cases, which helps me build my reputation in the community as somebody that can really settle cases. So what I want to know when I talk with them is what are their goals? What are their fears? What do they know or think they know about divorce? Who handles the family finances, and why is that? What can that client, potential client rather, tell me about the other person that might be helpful to the settlement process? They might tell you a lot of stuff that's not helpful, but chances are their perception of the other person is going to be helpful because you take a whole person in the mediation, not just their net worth. I also want to know, do I feel that this client can tell truth from fiction? In other words, are they a liar? Because if they're lying and you sense it on the phone, it might not be a good case for mediation. You want to know, is this client rational? You might not know that until you've talked with both of them. You might not know it until you meet with them. But in order to settle a divorce in this sort of a process, where you're not an attorney telling them what to do, they need to have a good dose of rationality. Also, you want to test the waters as to whether that particular client is able to listen, absorb, process, and utilize information. And that kind of cracks me up a little bit because I would say over half the time when I'm talking to somebody, they will tell me that their partner does not do one or all four of those things. But sometimes in a marriage relationship, people shut down and don't listen or process information or utilize it, but that doesn't mean that they can't do it in a settlement situation. So you want to know that, are they doing that with you, not necessarily with their spouse. You also want to give the client an opportunity in certain cases to get some ugly facts off their chest. In other words, an adultery case, which about half of mine are. They might want to talk about that. They might want to talk about, and that's the big one, is adultery. They might want to talk about just how discompassionate the other person is, how shut down the other person is, that there's no sex in the relationship, all kinds of things that chances are not going to play a big role in the mediation. And chances are they don't even want those factors to play a big role, or they probably would already be litigating. But they might want to tell you so that they know, that you know what happened, and then they can move on with the settlement. Which is another good reason to, continue to remind them that everything is confidential. You also want them to feel making some progress. So most of my phone calls, we end up with pinpointing of some issues. I don't phrase it that way, but I want the client to walk away feeling that I understand what their concerns are, and at least from their perspective what the issues are. And oftentimes the clients do feel better, I hear this a lot, after the phone call, and have moved forward emotionally, and they're ready to settle. That's pretty common, particularly with the second client, who oftentimes does not want to be divorced. The first client is pushing the divorce, the first one to call, and then they get their spouse to call. And lots of times the phone call starts off pretty ferocious because they don't want a divorce. But after they talk with me for a while, they're settled down, they're ready to move forward. What I've put here at the bottom, storytelling in mediation starts trouble. I wrote that more for the people that have been trained formally in mediation. If their training was anything like mine, one of the first things we were told to do in my training, and I'm sitting here with a lawyer working for me, and she just went through the training, and she learned the same thing, and that's to storytelling, to have the people come in and tell their stories. My opinion, you do it your way, but in my opinion, I like them to tell their stories in person to me, without the other person around in the intake call. And when we sit down to mediate, we're dividing up retirement, we're setting support, we're getting down to brass tacks. We're not storytelling, because to me that just starts trouble. That's my opinion. I hope you like my little baby. I sure had fun picking these pictures. So this third section, role of the neutral. Neutrals are educators. Your clients are going to look to you for well-researched, correct information. Be prepared. I break this down into 3 areas: the law, taxes, and financial planning, just like the CDFA exam. In terms of the law, you're going to want to focus on state and local law. But sometimes your jurisdiction might have unfair law. I call it outlier law. You may have laws or court procedures or what have you that they don't have most other places in the country. One of the beauties of being a CDFA, I find, is that when I sat for that exam, they're testing you on what is the law most places, which allowed me to compare the law, for example, the law of equitable distribution. I'm now able to compare what is the law most places to what is the law in Virginia. And in Virginia, I don't know if I have any Virginians out there, but the law is pretty wacky here in a lot of ways. I'm able to tell my clients, this is the law here, but it's not that way many other places. You don't have to apply the law. Only judges have to apply the law. What do you think? And then I usually throw in there that lots of times where the law is confusing or different from everywhere else, that's where the attorneys are making a lot of money. And maybe they want to be better. They want to be better than what goes on in court and choose what suits them. Because they don't have to apply the law, only judges do. Taxes, I think it's a good idea to know the tax code pretty much inside and out as it concerns divorce. Of course, you always want to remind clients that you're not functioning as an attorney, even if you are an attorney, and that you're not functioning as a CPA, even if you are a CPA. But I think you need to be able to not only spot tax issues, but have a pretty good handle on them. And by the way, I've noticed a lot of CPAs, they don't know divorce tax law that well because they're so busy doing so many other things. I get it. But you really need to be able to at least be able to quickly get that information. And the financial planning, as you know, divorce will be one of the dumbest financial decisions your clients will ever make. But don't scare these people to death. If they're in your office and they've hired you as a neutral, they're going to be getting divorced. Be positive, run projections. But, I mean, you know that some of those pie charts and bar graphs and stuff, I mean, they could turn your hair white in a minute. So look for balance in the portfolios. Look for their earning potential if you have somebody under earning or not earning. Look at their lifestyle choices. Maybe they're spending a lot of money to make up for emptiness in their marriage or something. don't focus on retirement if you don't have to. If these people are fairly young, don't get all hung up in that. If they're older, you don't have a choice. I know that. But just try to help them get through this. Obviously, it's worth it to them or they wouldn't be getting divorced. Know your limits. Don't speculate. Have sources. There's nothing wrong with picking up the phone in the middle of a mediation and calling your buddy the CPA or calling your buddy the, I don't know, the lawyer. Once again, don't give legal advice, but you can get information about a point of law. Gently bring clients out of their misinformation bubble. Remember, that information may have come from their mother. It may have come from their best friend who's been divorced 16 times. Oftentimes, it comes from their lawyer. I find that clients don't necessarily hear what their lawyer says. I live in a pretty high-end community. I know these lawyers are not telling the clients things that the clients tell me they're telling them. They don't hear it right. But you don't want to tell them, or everybody's stupid out there. I mean, they may need these people later, and they may be good people. So if they're saying things that are just not correct, just kind of be nice about it. Remember, and I wrote it 3 times, you're not an advisor, you're not an advisor, you're not an advisor. And after I wrote that and turned my slides in, I realized, there is a form of mediation where you are permitted to advise. It's called directive mediation. You can tell the people what to do. It's very frowned on by my certifying organization, but it is a style of mediation. But you need to be sure, if you're advising people, that you're giving advice that is to the benefit of both of the people. I suppose I could say to the detriment of both of them. And that's a hard thing to do in a divorce situation. Neutrals are information managers. You will be gathering key financial information. A lot of people want the clients to do this beforehand. I give clients a list of documents as long as my arm and leg put together, but I also let them know that it's up to them. A lot of people are more comfortable waiting until the first session to find out really what it is that they're going to need before they run around the house gathering documents. So that's up to you. Sift and present information in a manner that's understandable to everyone. That's just going to depend. And I've noted that every case does not require a spreadsheet or a pie chart. If you insist on putting together the information in a certain particularized manner and they're going to pay for it, and they don't feel that they need it, it might not work. I have a lot of clients in the financial industry and just a lot of really smart clients that have everything on QuickBooks and spreadsheets and the whole bit, and they bring in information. I don't need to redo it. So that depends. But it needs to be understandable to everybody. Once again, both parties must completely understand the financial facts upon which they will be making their settlement decision. This is one of the reasons I noted why I like in-person mediations the best. I like to be able to look at people, make sure that they understand what's going on. It's easy to say, yeah, I get it, when you're doing a phone conference, for example, or even an email mediation. A lot of people are doing that. But I want to look at these people's faces. And I think I'm a pretty good read of faces. I bet you are, too. I tend to have the rule of 3. If there's something complicated going on, stock options, annuities, something of that nature, I'm going to ask the person whose name is on the asset to tell me the story of the asset. Then I'm going to repeat it back and make sure that I understood, whether I understood it or not. I'm going to repeat it back. Let me make sure I understand you correctly, bumpty-bump. And then I'm going to turn to the other spouse, and I'm going to say, what's going on with that asset. So meanwhile, everybody's heard it 3 times. Sometimes people want to say, yeah, I understand all about the family finances because they've been being yelled at for 20 years for not paying attention, and they don't want to get yelled at again. So you be the one to explain the finances to the spouse who you perceive or who you know really doesn't get it. And lots of times there is one spouse that doesn't really understand. Don't set them up to get yelled at one more time, or don't put them in a position where they're shy to speak up because they're afraid that they're going to be yelled at. Well, right before I break for questions, if we're going to do questions in the middle, if anybody has any, is the third part of what you are as a neutral, and that is a referee or a settlement expert. This is the art of mediation. You want to neutralize language. For example, wife says, my husband never listens to me. The neutral says, well, he is now, and that's what matters for your settlement. Husband says, my wife always spent too much money, and now she's taking all my money again. The neutral says, I hear that you're concerned about being broke after your divorce. And then move into expenses. How are you going to make it happen? She's not taking your money. This is what the law says. Wife says, my husband has no idea what it costs to raise kids around here. The neutral can say, a lot of couples divide responsibilities when it comes to raising children and purchasing things for them. Now it's going to be important for you, the person who knows everything, to make a list of child-related expenses. Now you have the dad's attention. Husband might say, I'll never be able to make as much money as my wife. The neutral can say, this is our opportunity to help you figure out a way to maximize your income-making potential. All for different perspectives. For example, with child support, there's a variety of ways in which parents support their children. There's a variety of ways in which expenses can be shared. So if one person's dead set on splitting expenses 50-50, give them some examples about other ways expenses are shared. An example in equitable distribution might be if one person says, you know, they should get X percentage and the other person says, no, you should get Y percentage. Sometimes you just split the difference. It's completely uncreative, but sometimes that's all it takes. Well, a lot of people in such a situation would split the difference. What do you think about that? Why would that not work for you? And sometimes they're stumped why that would not work. You also want to talk about fair versus practical. Sometimes the settlement is really unfair, but it's really practical because it's going to take, you know, because somebody has tremendous earning potential and the other person just doesn't. And maybe they do need more of the assets as a result. And maybe that's going to work out for everybody in the end, particularly if they have children. Compared to the norm. What is normal? Well, in this divorce settlement situation, normal is oftentimes, what do your other clients do? If you got a lot of experience doing this work, you've seen clients with similar situations settle things similar ways over and over and over again. So that kind of becomes the norm at your firm. The norm, quote unquote, is also how attorneys normally settle things in your area, how judges normally decide things. I know where I am, retirement and the equity in real estate is oftentimes divided 50-50. I mean, like oftentimes, but that's completely not the law. So the norm is 50-50. In my mediation, the norm is still 50-50. That's not the law, but it's the norm. Number 4, encourage appreciation and respect. I see that over and over and over again. One person has felt unappreciated for their breadwinning. It's usually the breadwinning and the stay-at-home mothering and homemaking. And they're still looking for that appreciation in the mediation. And once they get that appreciation, really, they feel it from the other person, the case can be settled. That's really important. I mean, I wouldn't have known that until I got some experience under my belt. But if I sense stuff going on, I try to make that happen earlier rather than later. And then the last important point in terms of neutrals as referees is these people are coming into you with 20 years, whatever, of bad communication patterns. And one of my favorite ways of explaining this is these 4 horsemen of the apocalypse, which is a quote by a guy named Dr. Gottman. He's a therapist. And he says the 4 communication patterns that break up marriages are criticism, defensiveness, contempt, and stonewalling. There's no reason for any of this. These parties are getting divorced. They don't need to be defensive. You're not the judge. And if they're defensive, it's because the other person is criticizing them. There's absolutely no room for that when you're settling a case. Contempt, eye rolling, kind of exasperated sighing, all that's unnecessary and just starts trouble. Stonewalling, such as evasive answers, refusal to communicate by silence, non-answers, that's just unacceptable. That's people have to be there in good faith to settle the case and move on with their lives. And if they're not, have an attorney referral list handy. That usually elicits better faith. So I'm going to stop at this point. Maybe people have some questions.
Hi, Robin. Could you switch to the next slide? I think we're behind on the information manager slide.
Oh, sorry. There's the neutrals as referee slide. Sorry, I got one behind.
Perfect. And we do have a few questions.
Great.
Shannon asks, do you always conduct mediations with the parties in the same room, or do you ever operate as the go-between with the parties in separate rooms? If so, which method is more successful than the other?
I have only done one mediation in 7.5 years, where the parties were in separate rooms. My policy is not to do any cases where there's a history of domestic violence, but I was begged by one of the lawyers in town, please, 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 please take this case. These people need you. You're the only mediator I know that could settle this case. I took the case. I put them in separate rooms. I did not settle the case. But my clients are so screened before they come in from these lengthy intake calls that, no, I do it in the same room almost always. I'd be more willing to do it in separate rooms if they needed it that way, if they didn't have children. But if they have children, they're going to be having to communicate for the rest of their lives. So I want them in the same room. Plus, it's more efficient. It saves tons of money. Saves them tons of money. So that's my answer to that. Thanks for the question.
All right. What do you say if one party asks, what do you think we should do about a particular financial settlement, if they ask for your advice?
Yeah, I get that. I get that all the time. I say, what I think really doesn't matter. You could have 10 different people and get 10 different answers, and then I go through the things that I've been talking about in terms of, well, this is what chances are a judge would do around here. No guarantees this is what a judge would do, but this is kind of how things go around here. This is oftentimes how cases are settled. I mean, I lean a lot on, letting them know that my clients are really smart, because my clients are really smart, almost to a client. They're pretty smart people, and I'll talk about what they do. I really will not say what I would do, but I'm a human being. If they're going down a path of something that's really giving me a headache, I'll let them know that that's something that I just don't think that I can write up. But if they're in the neighborhood of something that's pretty much, in the bell curve of normal, right up there in the top middle, I'm not gonna answer the question.
Okay, and let's do one more. You mentioned showing appreciation, encouraging appreciation, for example, of a breadwinner versus a homemaker. How do you encourage your clients to show appreciation?
You know, probably not in a very subtle manner. I usually, if I've heard about it in the intake call, I might get to the other person before the mediation starts. I'm not going to tell them what the other person said, but I might say, you know, in my experience, stay-at-home moms, for example, oftentimes feel underappreciated. So I just want to make sure in this mediation that, if there's an opportunity, you might want to let mom know that she's a good mom if that happens to come up. When I talk to my stay-at-home moms on the phone, oftentimes I let them know, probably because I've been a working single parent for years, I let them know how hard it is to make a buck if they don't know. Maybe they haven't worked in many years. Maybe they've never worked with children. So kind of let them know, getting up and going to the office every day is really, really, really hard. So taking care of kids. I've been a stay-at-home mom and I've been a working parent, so I guess I'm real comfortable with this. When we're in the mediation, if somebody mentions 2 or 3 times, you never had any respect for, me working and coming home and taking care of everything at home, I'll just straight up say, is there something that you can say right now? Because this is obviously a problem, and this is not going to go away. And I guess I jump into sort of like a therapy 101 kind of a thing, without benefit of license. I hope that helps.
Alrighty, well, we'll get to some more questions later, and you can go ahead with your presentation.
Okay, thank you. So, how not to get sued? This is a favorite. I don't know exactly. It's a tough one. As I said before, you're probably going to be a guinea pig. You are probably going to be a guinea pig in your state. And I think one of the reasons why is because I think a lot of people that come to mediation, which is essentially what you're doing, whether you call yourself a mediator or not, they're pretty level-headed folks. At least that is my experience. And they're not looking to sue the mediator. I know a lot of mediators. I don't know any mediators that anybody's ever sued them. But you do have to be careful. So you're going to have a written contract. And in that written contract, we call it an agreement to mediate in Virginia. And ours is dictated pretty clearly by our certifying organization. I've monkeyed with the language a little bit, but I don't mess with a lot of it. I kind of take the one that was given to me in my training, and in my, it gets tweaked every now and again when I go to conferences and such. But what you want to make clear is that they know your role. Remember that slide with the hats. What is your role? What are the rules that apply to you? In my state, Virginia, the rules that apply to me have much to do with confidentiality. There's detailed rules with regard to that. And I got every single one of them in my agreement to mediate. The rules that apply to the client, in my agreement, my agreements to mediate, which is what I call my contract, there's only 2 rules. Good faith, that they be there ready to settle the case, and full disclosure. That's it. And then I check out in great detail what my fee structure is, so that there's no misunderstanding. And that is particularly important. And I've tweaked this every 3 months, it seems like, to get it just right. This is particularly important as concerns how are you going to charge the clients as a couple when you're only talking or working with one of them outside the mediation. For example, one of the clients emails you every 5 minutes, and you got to bill for that. And the other client saying, well, why is my family getting a bill for that when you're only talking to the other person? What were you talking about? And what do I say? I can't tell you. It's confidential. So it's very awkward. I used to not charge at all, but I got into too much trouble with my business consultant, and it was really costing me a lot of time. So I do now charge fees, as I should, but it's very teched out in my agreement, and it's very clear that if one person has a lot of questions, everybody's getting a bill. And I'm not going to tell you what their questions were about. Awkward, as my kids would say, very awkward. You want to remind the clients that you are not permitted to give them legal advice. But I've said don't be obnoxious about it. I've co-mediated with several people during my training days, and anytime any client asked any kind of information about anything that had anything to do with the law, they would say, I am not permitted to give you legal advice. Well, you can't give advice. You can't tell them what to do, but you can tell them what the law says. There's a lot of things that you can do. I'm going to get examples follow this. It's so obnoxious if every question that they have, you say, I'm not permitted to give advice. Give them information. It's fine. And then I noted that as a CDFA, if you're a CDFA and a financial planner or a CPA, you need to let them know that you're not acting as an advisor to either of them individually, but as an analyst and an educator. Once again, with the caveat that if you're doing the style of mediation called directive, you might be giving them advice, you might be telling them what to do, but it better be beneficial or equally beneficial or equally detrimental to both of them. Next slide, examples of information versus advice, and I've given a lot of these. I'm going to spit them out really quick because I had a hard time, as an old attorney, distinguishing between the two when I started my practice. Now it's second nature. So what's information versus advice? And these are all examples of information. Anecdotes from your and your college practices, short stories are good. In other words, what do people do in similar situations? What often happens in court? What often happens in attorney-driven settlements? Copies of the statutes for equitable distribution, spousal support, and child support. My clients always have copies of the statute. It comes in a packet of information I give them when they sit down. Here's the criteria the judges consider. Attorney-drafted articles regarding ED, spousal support, and child support, ED being equitable distribution. And, I don't know why I wrote attorney-drafted. It doesn't have to be attorney-drafted. Just articles that have good information. You're not giving them advice. You're giving them an article. Here's an article. Read it. Take from it what you want. Complex areas of the law, i.e. areas where the fees tend to be high and satisfaction's low, can be explained and discussed. For example, in Virginia, the law says from the date of separation forward, most assets and most debt acquired are separate. Well, boy, oh boy, does that start a lot of litigation. So we have a lot of conversations about that. I don't tell them that they should apply the law, should not apply the law. We just have conversations. Do they think that's fair? I let them know it's not that way. In most other states, we talk about why the law might be that way, why they might not want to apply the law, stuff like that. More examples of information versus advice. The stomach ache test, that's what I call it. I tell my clients straight up when they're going down the path of something really unfair, and I had it the other day. One of the parties felt very, 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 very guilty for certain behavior that was the last straw in ending the marriage. So he basically wanted the other party to have everything. And I told him, I said, it gives me a stomach ache to hear that because you're not going to feel guilty for the rest of your life. But I think you might, have a financial problem for the rest of your life. I also say sometimes I'm just not comfortable writing that up. Let's talk about that some more. I also let the clients know, without giving them advice, that if they go with, the Plan X, that their agreement's vulnerable to being overturned, because if down the road they decide that maybe that wasn't such a good idea to give the other person everything, maybe they'll be able to hire an attorney that will get the agreement overturned for a reason that perhaps they didn't have the requisite intent or the requisite ability to form the intent to enter into a contract. You know, maybe they were not of sound mind or something like that. Duress, coercion, fraud. I mean, there's all kinds of reasons to overturn a contract. So if the contract's looking very strange, very unfair, I'm not going to write it. I'm not giving them advice. I'm just not going to write it. I oftentimes ask clients that are asking for the moon to explain. I say, you know, tell me, with the other client sitting there, why that seems fair to you. And that elicits discussion. And lots of times the discussion ends with, it seems fair because he's a jerk or she's a jerk. And we don't do a whole lot of punishing at my firm. I don't encourage it. I don't encourage settlements based primarily on punishment. Sometimes people need to punish a little, and sometimes I'll ask them. Sounds like you need to punish your wife for sleeping with your neighbor. What's it going to take before we can move on with this? Because you're not getting everything. What's it going to take? Split the difference. I talked about that before. Sometimes attorney's fees matter. Sometimes I just say to them, you know, I'm not going to say who's right or wrong here, but if you split the difference in your two positions, it might save you, you know, $60,000 in attorney's fees. What do you think about that? What do you think? Send it back to them. Sometimes I write up sort of crackpot agreements if they just really, really, really insist. And I know the person that's giving away the store, for example, has some pretty good earning potential. I'll write it up, but you better be sure there's a note on that agreement in bright blue ink that says, you sure about this? This is a continuation of the How Not to Get Sued mini-series. So screen your clients for desire and willingness to move forward with their lives. Avoid shoot the messenger types, you being the messenger, and those who have venomous anger for their spouse. If they have venomous anger for their spouse, you can be sure they're going to turn it around to you. I learned that as an attorney too. If they yell at their spouse, they're going to yell at you. If they're cheap with their spouse, they're not going to pay your fees. If everything their spouse says is stupid, guess who's stupid next? You. So screen your clients. Get out of a case when a client is hostile or highly disrespectful to the process, you and or your spouse. I've only had to talk someone out of the mediation once. Guess who was the only client ever that subpoenaed me in court? I didn't end up having to testify. And I didn't catch that in the intake call. They were very nice in the intake call, but you can't do that. They're the ones that'll sue you. You know that. A client accuses you of being not neutral in any way, such as gender biased or biased against them personally. I had that happen once. The husband said once, I think you're biased against men. I said, no, I'm not. We moved on. He said it again. No, I'm not. We moved on. He said it a third time. I said, that's the end of the case. He threw his credit card at me, and I ran it through for the time we spent. But, you know, and now that I've been doing this for a while, if he said it once, I think that would end the case. Not to mention hurt my feelings, but who cares about my feelings? That's the scary stuff. A client trusts nothing that you say. I haven't really had that happen, but I've heard about that. A client challenges everything that you and or the spouse says. I had that happen the other day. Client challenged not everything the spouse said. That would have been a bigger problem. But he was definitely looking to see if I knew my stuff. And I guess I did, and I passed the test, and then he relaxed, and we moved on and settled the case. And the last is nothing you do suits them. I had that happen one time. I gave the clients their money back, and I felt really, really, really bad for the other client. I'm sure after that, it was the man that I couldn't please, but the wife said, now you've alienated the mediator too, because I don't think I could have done anything to please them. So, and I didn't, you know, I didn't want to get sued. Nothing I did please them. The final slide on avoiding a lawsuit. Stay away from cases where you think one or both of the clients may be hiding assets, hiding money, at least in my state, is straight up considered fraud. That's what we call fraud. That's considered black letter law. In other words, if it's determined that a client is hiding money during a mediation, that agreement is avoidable. It will probably be overturned if they end up in court. But you need to know not all clients hide money. I have some colleagues who are forensic CPAs, and they think that I'm insane to mediate and that everybody hides money. But, of course, they're only involved in the cases where clients are hiding money or it's suspected. Believe me, at least in my experience, not all clients hide money. If either client's uncomfortable without formal discovery and there are no plans to do this, in other words, they don't both have attorneys who are moving forward with discovery, you cannot do that case. You cannot do that case. You can engage the services of a forensic accountant, but in such a case might not be appropriate for neutral work. If somebody really feels they need the assistance of a forensic accountant, probably not a good case for neutral type work. And even if you have the skills to be a forensic accountant, it's not your job to be looking for hidden assets. If you find that there's hidden assets, probably that's the end of that case. But you are not the forensic analyst. Finally, wrapping up, the do's, and I believe there should be a apostrophe there, but I was voted against. The do's, keep the focus on your client's children if they have them. Keep the focus on their children. If one of the clients is going to be poor, even if the division and distribution of assets would seem fair at, let's say, 50-50, if they're going to be living under a bridge when the kids come to visit, you need to keep that in mind. Practice compassion. You can practice this on your kids, on your neighbors, on the grocery store checkout person, whatever. If you don't have the capacity to be compassionate, and that is not a habit, you're going to have a hard time mediating. Clients will feel that. You need to be comfortable being in the middle, which I believe requires compassion. You need to be able to establish connection with both clients. If you really can't, then probably that's not a good case for you. You need to keep an eye on your client. Extreme sadness and anger can make it impossible for a person to think clearly. There's no worse time to divide assets and set support than when people are going through a divorce because they're upset. But unfortunately, that's when they're coming to you. But make sure that they can, that they're sticking with you, and they know, that they're able to make, that they're fairly clear-headed and that they understand what's going on. Be encouraging. Be efficient. Support the use of professionals and other. If they need a CPA, give them a referral to a CPA that's not going to cost them an arm and a leg. One of the most important referrals I make all the time is a good mortgage broker, so they can see, if you know that they're not going to qualify for a mortgage and they're insisting on getting the mortgage, send them to your mortgage guy. Therapists too. Career counselors, that's a great one. I send my stay-at-home moms all the time down the street to the community college so they can investigate what kind of 2-year degrees and certificates they can get to go make money if it looks like they need to do that. Finally, the do not. Don't touch your clients. I was a fitness instructor for many, many years. I'm used to touching people. I learned in mediation that is a no-no. Somebody else could probably get away with it. I'm sure they could. I thought a reassuring pat on their forearm or shoulder or something might be helpful. I learned real quick not to do that. You might be able to get away with it. I can't. Don't joke around unless both clients are joking around. I've had many, many mediations that we're laughing a lot. But it's because usually they've been separated for a long time or they just get along really well and they're both kind of jokey people. Otherwise, no way. I had a case referred to me recently because the mediator was a little bit flip and jokey, and they left. Don't blab. Even if you're talking to your colleagues at the office, and it's perfectly appropriate because they've signed confidentiality forms or what have you, they want to think that it's a private process just between you and them. If you needed to talk to your attorney buddy about something, they normally don't want to hear about that. They want you to be the expert. They don't want to think you're talking about their stuff. Don't talk about yourself mostly. I've been divorced twice. I've done it all, seen it all, personally, professionally, whatever. They don't necessarily want to hear about it. I throw in things where it's helpful for the compassion part, But if I got a story about how I split assets and it's perfect for them, I'll just say, you know, I had a case once, whatever. They don't want to hear about you. Don't be a smarty pants. Talk at their level. That's really important. Don't talk over their head. It's not going to help. It's not going to help anything. Chances are your clients will be smart. I know I'm out of time. Finally, don't tell your clients what to do. And I like that dog picture. 3 is never a crowd in mediation. It is, find it a good triangulation. So that's it. I'm really happy to help with questions, both now or if you want to send me an email later. Here's my contact information. So Laura, does anybody have any questions?
We do actually have several questions. I think we have time for maybe 1 or 2 before we need to wrap up.
I'll answer quick, and they can always email me or call me.
Okay, perfect. Once the agreement is made, how does the settlement get implemented?
I write up the agreement. They sign it with my notary, and it's different places. But in Virginia, they need to then compile that with their other divorce documents and file it with the court. And I strongly recommend that they have an attorney do that. And I have a list of attorneys that do that for my clients very inexpensively.
Okay. As a mediator, if the mediation doesn't work out, can you be called as a witness in litigation?
Never. Never. No, it's absolutely confidential. They cannot. They can subpoena me. I had a client do it, the same one that I kicked out of my office for bad behavior, but the judge is not going to allow you to testify. It's confidential. It's real serious. At least in Virginia it is.
All right.
But as I tell my clients that own businesses, I don't believe the mediator confidentiality has ever been tested in the bankruptcy courts or the tax courts. That's something to be aware of.
Okay. And let's do one more. Someone asks, if I'm not an attorney, can I be a successful mediator?
Yes, absolutely. Absolutely. Just like I did not have my CDFA when I started. I am not a CPA, but that's probably how I blew through my second marriage, was really getting a handle on divorce financial planning, which I can't believe I practiced law as long as I did and didn't have as big a handle on it as I do now. Kind of sad that I was able to do that, but I really spent a lot of time. And I think that if you find, a buddy, an attorney that you can share notes with, if you find really good blogs, attorneys say that the blogs are no good, but they're the ones writing them. You can bone up on the law. It's only one area of the law that you need to be aware of, not like sitting for the bar exam. So yes, absolutely. But you have to be studious, just like I was to learn the tax stuff and the finance stuff.
All right. Well, that seems like a really good place to end. Thank you so much for your time, and thank you to everyone who came and attended the webinar. I'll send all of the remaining questions to Robin in an email so she can answer those. And please let us know if there's anything else we can do to be helpful. Thanks again, Robin.
Thank you so much. Thank you, everybody, for listening. It was my pleasure, and I'll look for questions. And please feel free to give me a call. How'd you feel? You